Hello, everybody. Anyway, this is my English law channel. This lecture is carrying on about parliamentary sovereignty, and I could look at the limitations there too. Remember, well, what Bagehot said in his book, The English Constitution. He said that Parliament is omnipotent in all things except the power to destroy its omnipotence. So Parliament can pass any law, even laws which are for countries that the United Kingdom has no control over. It might seem an absurdity. Parliament can't pass a law which cannot then be repealed. So, for example, the European Communities Act saying the UK is joining the EU, Parliament had the possibility to repeal that, and indeed did. Or let's say the Act of Union, passed in 1800, Ireland, Great Britain united, and of course in 1921 that was repealed when most of Ireland left the UK, even though it was supposed to be an eternal union. But there are, in practicality, constraints to what Parliament can actually do. So in Blackburn and Attorney General from 1971, the celebrated Judge Lord Denning said, "In legal theory, one Parliament cannot bind another, and no act is irreversible, but legal theory does not always march alongside political reality. Freedom once given cannot be taken away. Legal theory must give way to practical politics." So, as we try to comprehend this principle, we have to realize that there is a difference between the legal and the practical limitations on Parliament's power to pass laws. I mean, Parliament could pass a law about what people wear on Tuesdays in Burundi, but Parliament would not be able to actually enforce that. So, the Statute of Westminster 1931 said that the parliaments of the dominions, then it was Canada, Newfoundland, Australia, New Zealand, South Africa, could govern themselves, and they didn't have to require Westminster's permission to do things. So this Statute of Westminster also said that no act of the UK Parliament, that's Westminster, would apply to a dominion unless that dominion asked that it did. So now Parliament could repeal the Statute of Westminster and say, well, we're taking back control over South Africa and Canada and so on, without the agreement of those countries. But in reality, that's not going to happen, and the UK would not be able to govern these countries. So there are other cases to look at. There's Coal Corporation and King, a 1935 case, which Lord Sankey, a judge, said the Imperial Parliament could, as a matter of abstract law, repeal or disregard the Statute of Westminster, but this is a theory and has no relation to reality. So that was a 1935 case, the Imperial Parliament, by which means the UK Parliament. Or there's another case, Jackson and Attorney General, in which Baroness Hale said, in general, constraints upon that what Parliament can do are political and diplomatic rather than constitutional. So we have to look at the rule of law, which is a core principle of English law, and indeed there's a group called the Global Rule of Law Forum, which is just an organisation for barristers or other interested parties that promotes this notion. So this is what Lord Reid had to say in a case called R on the application of unison and Lord Chancellor, 2017 case that went all the way to the Supreme Court. It was about a trades union. And Lord Reid said, at the heart of the concept of rule of law, there's the idea is that society is governed by law. Well, it might seem obvious. That doesn't mean that laws are always obeyed. Obviously, crimes are committed. That's why we have the police and courts and prisons. So no societies are perfect on this, but you get countries where the governments break their own law willy-nilly. So another thing Lord Hope said in the Jackson case, the rule of law is enforced by the courts and is the ultimate controlling factor on which our constitution is based. So constitutionality means certain limitations on the power of the government, state agencies, all sorts of other persons. So the notion of the rule of law is obviously not original or unique to the United Kingdom. It's part of the UK's uncodified constitution spread around the world. So it's important in other democratic countries too. They often have codified constitutions, usually do, and bills of rights. In the European Convention of Human Rights, there's a preamble, which is not part of the convention itself, and it alludes to the rule of law. And that's saying that's part of the legal heritage of all the countries that were going to sign the European Convention on Human Rights. The Universal Declaration of Human Rights That's why the UN said something similar, that human rights are guarded by the rule of law. So does the Treaty on European Union. So anyway, let's have a synopsis of the rule of the law before we dive in more into it in its particulars. So it might seem to be something that's hard to pin down, not really tangible. So the idea is that there are constraints on what government can do, and that everyone is governed by law, and that includes the government. The Prime Minister can't just say, we're outlawing the wearing of purple. The Queen can't just say off with his head, that kind of thing. So just because the government does it doesn't automatically make something lawful. So governments have to keep within their own appointed limits. So we don't want to have anarchy, and we don't want to have untrammeled power of the state, because it's like Lord Acton's dictum when he said power tends to corrupt, and absolute power tends to corrupt absolutely. Or like Aristotle's analogy saying, imagine you could put on a cloak which would confer invisibility on you. You could commit any felony you pleased and be certain to avoid detection. Wouldn't you be tempted to abuse this power, to go and slap someone or play tricks, get up to all sorts of mischief, steal things, exact vengeance, listen in on conversations? Most people would do that. So if governments are overmighty, they tend to get worse. And you see this in various tyrannies. People have no recourse to law. There's no constraint on what the government can do. There's no accountability. And therefore they can treat their citizens horrifically and get away with it. There's no free press to report it. There's no free elections to remove people from office. And they just won't face any legal consequences. They just get worse and worse. So anyway, law has to include certain features. We must know what the law is. It must be able to predict what's going to happen. It must be enforced in a fair and equitable manner. So everybody thinks that Parliament won't pass laws which are breaching the very notion of the rule of law, although Parliament actually can do so because of parliamentary sovereignty. So there's an expectation, not a law, that Parliament doesn't do this. How can a law break a law? It seems to be a conundrum. So judges have recognised this through statutory interpretation. There's a case about this in R and Secretary of State for the Home Department ex parte Pearson in 1998. It went to the Court of Appeal, and Lord Steen said, unless there's a clearest provision to the contrary, Parliament must be presumed not to legislate contrary to the rule of law. So therefore, impliedly, if there is a very clear provision to the contrary, Parliament could actually pass a law against the rule of law. So the Constitutional Reform Act 2005 was a major shake-up of the UK legal system. It changed the office of Lord Chancellor, which goes right back to the 10th century AD. It envisaged setting up a UK Supreme Court, removing judges in the House of Lords and so on. But anyway, it was a sort of a back-of-the-envelope thing, and it was as part of a press release which was mainly about a cabinet reshuffle under Tony Blair. But anyway, bizarrely, the Constitutional Reform Act of 2005 is the only statute which actually mentions the rule of law by name. Anyway, the Constitutional Reform Act doesn't actually say what the rule of law is, but it did say that the Lord Chancellor, who's also Secretary of State for Justice, the two titles go together, the Lord Chancellor has a particular responsibility to safeguard the rule of law. So anyway, the Constitutional Reform Act said that this law, it did not abrogate the notion of rule of law, and that the Lord Chancellor's role was to uphold the same. So the new oath was introduced for the Lord Chancellor, who's not a judge anymore, used to be a judge and a cabinet minister, and someone who's really in the House of Lords, effectively Speaker of the House of Lords. And this is the new oath has to be taken by the Lord Chancellor, that he will respect the rule of law, defend the independence of the judiciary, and discharge my duty to ensure the provision of the resources for the efficient and effective support of the courts for which I am responsible. So that was a major shake-up, him or her no longer being a judge, and recently we had a woman to be Lord Chancellor for the very first time. Anyway, so by tradition, the Lord Chancellor was always a barrister, not actually by law. So we've got to look at judicial independence. So judges are to make whatever is the right decision in justice and in law. These two might clash. We want to do justice in the individual case, having regard to the particular circumstance of the case, but the law says this, and though I feel very sorry for you, and yes, you haven't done anything wrong, but the other side have been ghastly, the law says I have to do this, so sometimes I have to do something which goes by the law but is unjust, or vice versa. I say, well, I'm going to do justice, even though the law says I should do whatever. There are some very difficult situations they've got to negotiate, but judges must be free to make their judgment, however popular or unpopular that might be. As the old Latin tag says, fiat justitia ruat caelum, let justice be done, though the sky should fall. People are going to say you're doing it because you're racist, or because you're against the ethnic minority, or you're against the ethnic majority, or because you're feminist or masculinist, or because you're prejudiced towards the poor or towards the rich, or you like him personally, or you hate her, or whatever, or you're moved by the media, or you're deliberately contrarian, or you want to be unpopular just to prove a point, or you're just trying to suck up to the tabloids. Whatever you do, someone's going to be angry. You can't please everybody. Somebody's got to lose every case, and they'll always say it's unjust, and they'll always say it's because of bias, and you just have to not let that bother you and do the right thing. So the judges have got to be independent of the government and indeed of the opposition. So it's crucial in order to rein in executive power. There's a thing called judicial review. An executive decision can be submitted to the courts, and they can say, no, that's unlawful, or they can say, yes, it's lawful. About 3/4 of the time they say it is lawful. Not really surprising, the government acts lawfully mostly. But some things can be said to be ultra vires, beyond the legal authority of whoever made the decision, or the opposite is intra vires, within the legal authority of the decision maker. This is what Lord Wolfe had to say about it. One of the most prominent of the judiciary's responsibilities is to uphold the rule of law, since the rule of law is what prevents the government of the day from abusing its powers. So there was a Lord Chief Justice who was speaking about this in 2006, giving evidence to the House of Lords Constitution Committee. He said, on the question of who is responsible for upholding the rule of law, the Lord Chief Justice told us that it is the role of the judiciary in practice to uphold the rule of law, to apply the rule of law, to enforce the rule of law, and to do what they have to be independent of outside influence. Anyway, so try and spell out what the rule of law is. There's so many definitions. Well, Sedley says everybody believes in the rule of law, but few people could tell you what it means. For everyone who could tell you, there are two others who would say you're wrong. So it's difficult to grasp, but anyway, we know it sets some boundaries on what a government can do and is intended to guarantee individuals his or her rights. And there's a spirited debate about the rule of law. Go back to our old friend A.V. Dicey, that Oxford professor, and he said there are three aspects of the rule of law. First of all, that there is no punishment without crime. There's no punishment without a crime. You know, the law's actually got to say this is a crime. You can't be punished just arbitrarily. Well, you've got a criminal face. I don't like you. No, there has to be a crime somewhere. You know this is a crime, and therefore, if you break that, you know you face criminal sanctions. Second of all, that everybody is subject to law. I'll come on to that, but criticise that one, that maybe he's wrong there. Third of all, that your liberties are best protected by common law. Now, the thing about everybody's subject to law, but there's some sovereign immunities. So we're not, and sometimes, yes, we all are subject to law, but some people, it's a bit different because of their position. It's not on an equal footing. So Lord Bingham, a great law lord who died only a few years ago, you read his magnificent book, The Rule of Law, and it's written in absolutely crystalline prose. As only a top-ranking barrister could compose. And he said the trouble with the rule of law is it just means hurrah for our side. So what does it really mean? He said the core of the existing principle of the rule of law is that all persons and authorities within the state, whether public or private, should be bound and entitled to the benefit of the laws, making them take general effect in future and publicly administered in the courts. That's another thing. We have open justice. Anybody can wander into court, watch a case in progress, even if you've got nothing to do with it, and the media are free to report what goes on. There are some exceptions if the case touches on national security, or there are some child witnesses sometimes, or occasionally the identity of complainants in the case of a alleged sexual abuse case is not revealed. But Lord Bingham, his definition was later taken up by the European Commission on Democracy and Law, the so-called Venice Commission. So Bingham, he went into 8 sub-rules. We had that one sentence definition. But in his very celebrated lecture in 2006, which he later turned into a book in 2010, he said there are really 8 sub-rules to the rule of law. Number 1, the law has to be accessible and understandable. It's got to be lucid and predictable. That's number 1. So if I do this, I know that's illegal. If I do the other, I know that is legal, and so on. We have to know where to find the law, because if it's all just a mess, if it's too arcane, then people can break the law without realizing that they know what the position is. So second of all, questions of legal right and liability should ordinarily be resolved by the application of law and not the exercise of discretion. So more on number 2, we can't leave it up to the individual personality of the judge too much. Yes, they have some scope, but be unfair if she said this is legal and another judge in the very same situation said no, it's illegal. We need to know what it is. So we don't want to allow judges too much latitude because that would be unfair. On the other side, we don't want to be totally mechanistic because we remove the human element and it might not take into account the particular circumstances of a case. So coming on to 3, he said, the laws of the land should apply equally to all, save to the extent that the objective differences justify differentiation. So when we say there's a sovereign immunity on this issue, well, that might be different, okay? So because the Queen is different, then she's treated differently. For example, some private correspondence of the royals is not released under the 30-year rule. Almost all government documents are released after 30 years, but the sovereign's got an exemption, maybe because the sovereign is different, or maybe that doesn't meet the standard of objective differences which justify differentiation. Or, okay. And then number 4, he wrote, my 6th sub-rule expresses what many would with reason regard as the core of the principle of rule of law. Ministers and public officers at all levels must exercise the powers conferred on them reasonably, in good faith, fairly, and for the purposes of which the powers are conferred, without exceeding the limits of such powers, and not unreasonably. What a mouthful. There's so many parts to that. So act reasonably. Who's to judge? Well, I suppose judges are to judge. That's very tricky to say whether it's reasonable or not. Depends who you ask. Well, the test is often the man in the Clapham omnibus. What would the reasonable man mean? I don't know how we can find who this reasonable man is. I'd like to meet him. And in good faith, as in they're doing it honestly, they actually mean what they say. Fairly. Again, that's like reasonably. It's just indefinable. And for the purpose which the powers are conferred. Now, this is one where he gave an example that there was some sort of Prevention of Terrorism Act, and some chap stood up at the Labour conference and he shouted some words of protest, and he was arrested under the Terrorism Act. And Lord Bingham said this was really abuse of the statute because that was not the purpose for which the law was passed. The law was to deal with people who are trying to kill others or something, not people who are saying something which Tony Blair finds a trifle disobliging. Okay, so they have to act within the limits set as well. All right, let's go on to number 5. He wrote that the law must afford adequate protection for fundamental human rights. This would not be universally as being accepted within the rule of law, as in not to kill people unless it's unavoidable, not to torture people and so on. And yes, some use of force is allowed, but it can't be excessive. Okay, so number 6. Means must be provided for resolving without prohibitive cost or inordinate delay bona fide civil disputes which the parties themselves are unable to resolve. So civil disputes is not criminal, to do with divorce, contracts, things like that, intellectual property, defamation. So it shouldn't be too expensive, because otherwise there's no access to the courts. The saying like the courts are open to all, just like the writs, as in so only if you're very rich. That'd be wrong, and they shouldn't be too slow. Remember, justice delayed is justice denied. Bona fide means when they were genuine civil disputes, not vexatious ones, which should be dismissed very quickly. The courts don't want to be clogged up with really trifling disagreements. So it's very petty. Ideally, sort it out amongst yourselves. Okay, and then number 7, adjudicative procedures provided by the state should be fair. All right, so equality of arms. If you have a defence barrister, you've got to have a prosecution barrister. They have to disclose evidence in advance, so they're not able to spring ambushes on each other as they do in courtroom dramas. The judge should not be taking sides. Everyone has a fair hearing, presumption of innocence in criminal cases, or things on the balance of probabilities in other cases, nemo iudex in causa sua, things like that. So number 8, the rule of law requires compliance by the state with its obligations in international law as well as national law. Okay, so the government shouldn't breach international law. And this is contentious because this internal market bill, which the UK government is trying to pass right now, is agreed by consensus to be in breach of international law. So it was a very dubious whether the liberation of Iraq in 2003 was legal or not, and Lord Bingham thought it was not, said it was a grave breach of international law. So let's look at what legality is. Anyway, so Lord Bingham said that legality is really the foundation of the rule of law, and it means that individuals can only have their liberty constrained within the law. You can't be arrested without good reason, you've got to be released within 24 hours or charged, things like that. So this is a statutory power, sometimes it's common law, as in arisen from past practice and judicial decisions. Okay, so the key to this here is the government must be able to point to the law as the ground on which its decisions are taken or its action is taken. There was Entick and Carrington, 1765, and this shows what legality is all about, when the court was willing to uphold individual rights. It was said by the Chief Justice at the time, Camden, if the power alleged by the Secretary of State and his messengers is law, it will be found in our books. If it is not found there, it is not law. So the Secretary of State couldn't just make something up as a law. They have to be able to point either the statute was passed or a judge previously said this is a law. The law cannot be just whatever a politician wishes it were. Anyway, so if you're going to interfere with an individual, saying you're not allowed to go here, or you're under arrest or whatever, you've got to have a legal basis for that, or distraining property, things like that. You have to have a legal ground for so doing. So there has to be lawful authority. Or Bradley and Ewing, in their book, they said the crime the government conducted according to law, the principle of legality, is a necessary condition for the rule of law, but insistence on legality alone does not ensure the state's powers are consistent with the values of liberty and due process. Anyway, so how did we come to this notion of the rule of law? So people said that it's content-free. Dworkin, that very famous American legal scholar, said it's a rule book. Now, Joseph Raz debated with him on this one. There's a famous ongoing debate between pupil and professor for decades. So those who suggest that this is a rule of law should look at the way law is formed. Is it through judgments that are passed? Anyway, so some people say that legal rules, they govern a person's behavior, and that you could plan your life on this basis, knowing that there are these legal rules and looking forward, and I'm going to do this and avoid doing that, and it would all be quite predictable. But you'd have to have judges who are really independent. This is what a legal scholar, Craig, said about it. The formal conception addresses the manner in which the law was promulgated, its clarity, temporal dimension. It does not pass judgment on the content of the law, provided the formal precepts of the law are met. So what Craig was saying is this view is not saying whether the law is a good one or a bad one, just saying what it actually is, and that we've got to have real equality. So if we depend upon the idea of the rule of law and legality, this wouldn't preclude the government passing immoral laws or evil laws, or laws which deprive us of our liberty. Anyway, these laws could still be open, prospective and clear, as in looking forward, no retrospectivity, as in saying anyone who ate ice cream yesterday is a criminal. Wait a second, even that's true, I didn't know that was illegal at the time. That would be unfair. Remember, laws are going to be clear, so I can avoid transgressing the law. I know I'm not allowed to do that, not allowed to go there, so I'm not going to go over there. I'm going to go over here, just to make it fair, so people can keep on the right side of the law. Anyway, that's my penny's worth on the rule of law. Toodaloo.